All right, we're going to get started right on time here because yesterday we went over with a lot of questions. So welcome everybody. Thank you for joining us. This is Eric Hauge, Executive Director of Homeline, and we're joined by Homeline's Managing Attorney, Mike Vraw. And you are tuned in on Thursday, June 25th, 2020. And this is one of our weekly webinars that we've been doing since mid-April every week on COVID-related pandemic issues and rental housing legal issues. Just a reminder, Homeline, we are a statewide nonprofit organization. Our main program is a free and confidential legal hotline that renters can call and get legal advice. And we advise folks in English, Spanish, Somali, and Hmong languages. As I mentioned, we've been doing these webinars for free online every Wednesday and Thursday afternoon. Wednesdays is designed for an audience of tenants and advocates, service providers. And Thursdays, like today, is for an audience of landlords and property managers. All of the previous recordings of our webinars are available on our website. We've added a COVID-19 tab on the top right of our website that has a drop down where you can access our general legal information page on COVID-19 related issues, previous recordings, and then registration for next week's, which we will continue next week as well. All right, with that, I'm going to hand it over to Homeline's Managing Attorney, Mike Vraw, to kick us off.
Thanks, Eric, and thank you all for joining us this week. We are talking about a new topic today. Some of you might have watched yesterday, and it's going to be similar to what we spoke about yesterday, but today, as Eric mentioned, we target the speech more towards landlords and property managers, whereas the Wednesday speeches are for tenants and social workers. The main topic we're going to get to in a second, which is sort of predicting how many evictions we're going to see once the eviction moratorium is lifted. But we'll start with a quick recap of kind of when evictions can be filed. There are two hurdles for landlords to get over when it comes to this question. When can I file an eviction against a tenant who hasn't paid rent, which is what almost every eviction is for in Minnesota. Well over 9 out of 10 evictions in Minnesota are filed for that reason, non-payment of rent. And so that's what landlords are curious to know about. And as we all are aware, I assume at this point, the governor has banned evictions during the peacetime emergency declaration. So this is always confusing. The dials that we have all seen on social media, in the newspaper, or on the news, where the governor says that these things can be open, whether a barber can open up, whether a restaurant can open up, at what percentage the restaurant can be open, whether a movie theater can open or a bowling alley. Those dials we've been watching have been related to the shelter-in-place emergency declarations, more or less, or the stay-at-home phrasing. The peacetime emergency declaration is a different declaration, and it's the key one when it comes to evictions, because the eviction ban that the governor instituted with an executive order in mid-March is tied to the peacetime emergency declaration. It has nothing to do with the dials that we've seen for the shelter-in-place. And the original peacetime emergency declaration was announced in March. It was renewed again in April, and then renewed again in May. And once again, it was renewed in June, on the 12th of June. This latest version goes through July 13th of 2020. So the landlord who's thinking, I want to file an eviction against a tenant right now in Minnesota for non-payment of rent, can't get past hurdle number one, which is the Minnesota hurdle. Can I file an eviction under Minnesota law? Until at least July 13th. Now, the governor could extend or renew that peacetime emergency declaration once again. As near as we can tell from looking at the statutes, there's not really any specific deadline or number of times a governor can renew that peacetime emergency declaration. The peacetime emergency declaration is going to end in one of three ways, I think. Number one, the governor will say, you know what, things are fine now. We've more or less solved COVID-19 to an extent that I'm comfortable with. The fatalities are down, the hospitalizations are down, the new cases are down. I'm going to not keep this going. I'm going to declare that the peacetime emergency declaration ends. The governor, I believe, has the power to unilaterally end that. The legislature also has the power to end the peacetime emergency declaration. Now, I don't believe they can do it today. I don't think the legislature has the power because they're not in session. At this point, whenever a peacetime emergency is declared by the governor, it automatically triggers a special session, which is very uncommon. We've all seen special sessions in Minnesota over the years and decades, frankly, recently. But those are normally when the governor calls for a special session. That's the one way a special session can happen. The governor calls for one. And once the special session is called, the legislature stays as long as they like. If a peacetime emergency declaration is renewed during a time when the legislature is not in session, then a special session is immediately triggered. Now, the last time the special session was declared in June, on June 12th, the Minnesota Senate actually voted to end the peacetime emergency declaration. Remember, the Minnesota Senate controlled by Republicans, the House controlled by Democrats, the governor, obviously a Democrat as well. The House, the Minnesota House, voted not to end the peacetime emergency declaration. And it takes both chambers declaring that they want to end the peacetime emergency. So either the governor will end it, sort of by saying so, making an announcement, the legislature will end it at one point, probably during a special session, or the governor will simply let it lapse at some point. We get to July 13th. If the governor doesn't do anything, I'm guessing what happens at that point is that the peacetime emergency declaration just fizzles out. How long will this go on? How long will the governor continue to renew these peacetime emergency declarations? We simply don't know. While we know a couple people in the governor's office, we don't really tell them what to do about any of this. I think, as near as I can tell, because we know some people that have more insight into what the governor might be thinking, as near as we can tell, the governor's waiting until the last minute each month to make these decisions. The governor wants the latest intel on the fight against COVID-19 before deciding to make decisions, which I guess makes the most sense. The sort of maddening thing for both tenants and landlords and people that work in this field is trying to plan for what's next. And so it's very difficult to plan beyond July 13th right now because we don't know what will happen on July 13th. So that's hurdle one for a landlord that wants to file an eviction right now against a tenant for non-payment of rent. Hurdle number two is the federal hurdle. I've given hundreds of speeches around the state, a couple hundred just to landlords. And one of the things that I say almost every speech is, this is almost all Minnesota specific law, which is usually true. There's some discrimination rules that are federally based. There's some city rules that might come into play, but generally it's almost all state law that we care about when it comes to landlord-tenant rules. But here, because of COVID-19, we have a federal rule that takes a role. And the role that it has is the CARES Act. CARES Act was passed in March. And again, we have a split legislature there. The House controlled by Democrats, the Senate controlled by Republicans, the president, obviously Republican, President Trump, passed the CARES Act. Now, the CARES Act doesn't just relate to evictions and housing. It relates to a lot of different things. There's hundreds of pages, but it does have a key housing component to it. And it also prohibits evictions. Now, it only prohibits evictions for non-payment of rent. The Minnesota moratorium prohibits evictions for almost everything, unless the tenant is endangering others on the property or they violate a rule that says no drugs, illegal weapons, prostitution or stolen property or domestic abuse on site. Those are the only limitations for what a landlord could file an eviction for in Minnesota right now, the only exceptions. The CARES Act is only about non-payment of rent. So for instance, if the Minnesota moratorium was lifted and a landlord wanted to file an eviction right now for having a tenant having a dog when they're not supposed to have a dog, they could do that. A breach of the lease, they could do that. Or for an unauthorized occupant, somebody that's not supposed to be living there, a boyfriend or a girlfriend. So the CARES Act is only about non-payment of rent. Also, and the CARES Act, by the way, goes till July 25th. That's the date that it stops banning evictions from being filed throughout the country. At that point, though, the landlord has to give the tenant a 30-day notice, a written notice telling them that, hey, I can file an eviction. I'm going to be doing so at the end of August or whenever they're going to be doing it. So effectively, if a place is governed by the CARES Act, then the landlord cannot file an eviction until late August. Now, who's affected by the CARES Act? Well, any place that has a federal subsidy The bigger umbrella, the easiest way to understand what it is exactly, although you'd have to look up what this covers, is any place covered by the Violence Against Women Act is covered by the CARES Act, which is a lot of different places where there's any kind of federal subsidy involved. The much harder question is 1 to 4 unit buildings where the landlord has a mortgage that is federally backed by Fannie Mae, Freddie Mac. Our best guess, this is a guess, but it is our best guess, is 20 to 50% of Minnesota rentals are covered by the CARES Act. I say that it's a guess because nobody's ever really asked that question. Hey, what's covered by the CARES Act before? Because the CARES Act didn't exist. And so knowing the answer to that question is speculative. Again, we know all the bigger buildings that have federal subsidies attached to them, but we don't know those smaller places where landlords only own a couple of units. Probably the only party in the world that can really figure that out quickly is the landlord themselves. They can go to whoever they got their mortgage from and ask, hey, how is this insured? Is this a federally backed mortgage or not? And the mortgage company can tell the customer, the owner. They wouldn't tell a tenant. So what we're seeing in other states where eviction doors have opened up again, that the courts have been reopened for landlords to file evictions, is that the states are requiring either proof from the landlord that they do not have a federally backed mortgage, or that they at least swear under oath that they don't have a federally backed mortgage under penalty of perjury. There's no official declaration from Minnesota's Supreme Court on that yet, partly probably because right now a landlord can't file an eviction anyway in Minnesota. But once the moratorium is lifted, then we'll see exactly what the court decides to do, or courts, because this is typically heard in district court or housing court in Hennepin and Ramsey County. But anyhow, that's sort of our state of when landlords can file evictions, which is obviously a critical question in trying to figure out all of this information. But I know why most of you are here today. We have a lot more people signed up today than we have had for a couple of our past weeks, because of the title of today's speech, Predicting the Eviction Wave. And we're going to get to some numbers where we're saying, hey, we think these are the baseline minimums of how many evictions we think are going to be filed, but we need to have some information that we share first to show you sort of how we're getting to the numbers that we're talking about. So how many evictions are filed in Minnesota in a year? Well, and go ahead and put the whole screen up, Eric, each time. That's fine if you don't mind. Over the last 5 years, you can actually, well, we have access to the court extract is what it's called, the information where we look at a lot of different information about evictions. There have been, this is the raw hard number, a little over 16,000 evictions filed per year. But evictions are not all residential evictions where people live in a rental. Commercial rentals, there are evictions there. If somebody's not paying their rent in a strip mall because their business is struggling, the last phase there is the landlord is going to file an eviction. If the commercial tenant that runs a shop refuses to go, the landlord's only recourse is to go file an unlawful detainer, UD, eviction, just like every other residential landlord in the state. That's the same case they file. So that shows up in our 16,000. A foreclosure. So single family home, somebody owns that and they're not making their payments. The bank will send all kinds of warnings. There'll be a sheriff's sale. 6 months later, roughly, or so, a little bit past that, the bank will file an eviction against that homeowner. That is the final step in the foreclosure process. And it doesn't get separated out in that 16,000 either. So our best guess is that 14,000, it's probably roughly 13 to 15,000 per year. There's some variation year to year on how many evictions are filed, but our best guess is that 14,000 evictions are filed each year, and that's based on averaging the last 5 years, from 2019 all the way back to whatever that is, 2015, 2014. So what we're using here is sort of our baseline per month. 1166, that's just 14,000 divided by 12. 1,166 evictions filed per month statewide. That's in a normal year, which obviously we don't have. This is not a normal year. Okay, let's go on to the next slide, Eric. All right, a couple other factors. The eviction moratorium began in mid-March. There were some evictions that were sort of stopped mid-eviction. That did happen. And they're still sort of in limbo, many of those cases. It's hard to know exactly what's happening with them procedurally. Different counties are probably going to be doing different things, which is terrible. It should all be consistent, but that's sort of what we've been seeing. But there are tenants that have not paid rent since March. In fact, there's some that didn't pay in March or even February. Not every landlord races down to the courthouse to file an eviction. If rent is due on the 1st, they don't go on the 2nd to go file the eviction. Some landlords file within the 1st month, some wait until the 2nd month. In general, they don't wait much past that, the 2nd month. Sometimes, but it's not common. We've done all kinds of eviction studies, and you can see that information, and it's just not common for landlords to wait past 2 months to go file an eviction. So we've got this very unusual pause in evictions happening this year. Obviously, the state has just said this is what's going to happen, and it's not like landlords are choosing to wait to file evictions. The choice has been made for them by the governor and the federal government in many regards. But we've got this long period where landlords have not been able to file evictions. And that might be in cases where people have not paid rent. I think there's probably a lot of cases where tenants haven't paid a penny since March. Now, some of those tenants have the money and haven't paid. I think that that's a lot less tenants than the anecdotes that we're hearing. I think that there's plenty of tenants that have paid some of the rent that they've owed since then. But there are tenants that haven't paid their rent, that are not current on their rent, whether it's by choice or they simply don't have the money. Another factor, the unemployment rate. Now, if you look at the national averages, Minnesota is actually doing much better than the rest of the country, average-wise, when it comes to unemployment. But we're still 5 to 6%, and this was as of June, percent higher than last year, the unemployment rate. Now, it's hard to know if that's a really accurate reflection of the true unemployment rate in Minnesota, or if people are underreporting that because of some of the additional money that's coming in, but that's the hard, raw data that everybody seems to rely on, is 5 to 6% more unemployment this year than last year. And that gets translated directly to, our tenants paying their rent. Again, some tenants have been paying and some have paid partially, but there is a looming cliff of July 31. There's what people are referring to an unemployment federal boost that's going on, where people are getting more money that's federally enhanced, basically. But that is going to stop on July 31, at least how things are set up right now. Now, one of the reasons why the eviction threat has been somewhat less threatening than we originally thought when March 15 first started this whole episode. The governor shut a lot of businesses down. The governor said you can't file an eviction. And people were worried, was April rent going to be paid by anybody? I mean, landlords were very worried about that. I can guarantee you that landlords were worried about it because we saw what they sent their tenants on April 1. Some of the biggest landlords in the state were sending out notices saying, hey, we realize you might not be able to pay your rent this month on April 1st. And so if you tell us when you think you can pay and how much you can pay, and by a certain date, we will, this was a common offer from the landlord, we will agree to waive your late fees if it's a reasonable sort of payment arrangement. Landlords were terrified that tenants weren't going to be able to pay much of anything and wondering if all the tenants in the state were going to go on rent strike or rent cancellation or something like that. The truth is most tenants have paid their rent. One of the reasons why most tenants have paid their rent, though, and have been paying their rent, is that there's been more subsidies available quicker than I think a lot of people thought would happen. So the $1,200 federal stimulus money, I realize there's people out there that are eligible for it, but haven't gotten it yet, but a lot of people have gotten it. Many people have gotten that money. Unemployment has been more available and a little more substantial than I think people thought would be. So people have had more money available, so the concept of doing a rent strike has been lessened substantially since the money's been more freely flowing. Let's go on to the next slide here, Eric. Thanks. So I'm going to, go back one, thanks. I'm going to talk about the Minnesota Multi-Housing Association for a second because they've done a report, or at least divulged some information. They have surveyed many of their members' units. So Minnesota Multi-Housing Association, I know it's a lot of landlords watching today, and you could probably define them better than I can. It's a landlord trade group. I think they say they represent about 200,000 different units throughout the state. I'm not sure how many members they have, but I remember seeing the 200,000 unit number thrown around. Maybe it's higher, maybe it's less, I'm not sure. anyhow, the report that they issued in early June that was covered in the media pretty extensively was that they had surveyed 34,000 rental units. So is that all Minnesota renters? No, not even close. There's 600,000 to 700,000 rental units that we know about. There are lots of handshake deals throughout the state. So what is that, 5-6% of Minnesota rentals? But it's the one that's the most focused on Minnesota. And it's a pretty substantial number. They've surveyed 34,000 rental units. And they have shared this information. By the way, this information that Minnesota Multi-Housing Association has shared, there's national equivalents to that. And the Minnesota version looks a lot better as far as rents being paid. The national numbers are much closer to 80% being paid, 80% of tenants being current on their rent at this point, versus what Multi-Housing Association has turned into the media. So let's look at what they've said. So first of all, they classify rentals in different classes. So the first one is Class A, newest, most expensive rentals. We can see 97% were current as of June 2019. 2020, 94% current. So it's a little worse for landlords, right? 3%. But if you look at it, just kind of the raw numbers, that's twice as bad as it was last year, the Class A rentals for landlords. Class B, it's nowhere near that drop off. It's still a 1% drop, though. Class B, 10 to 25-year-old properties is how they describe those. But a 1% decrease, 93 to 92%. And last, we have the Class C. So these are going to be older places, the more affordable places. Pretty substantial. Our biggest percentage-wise decrease is in these rentals, which isn't especially surprising. I think that if we had to guess about which jobs were lost the fastest in Minnesota, and probably throughout the country, it's those service industry jobs. And those are probably going to be people living in these places. And so a 4% decrease, pretty dramatic. We went from 92 to 88%. And we'll just kind of summarize this page on the next. Here we are. So, all right. 2019 in June, 92 to 97% of renters were current, right? And 3 to 8% were not current. This year, it's 88% to 94%. So we go from 3 to 8%. If we look at the bottom bullet point here, we go from 3 to 8% that weren't current last year to 6 to 12% this year. So maybe it's twice as many, you know, if we go from the 3% to the 6%, or whatever the 8% to 12% is, like 33%, I think that'd be the increase there. So, I'm sorry, it'd be 66%. So somewhere between 2/3 and double, 100% difference in delinquencies. And I can tell you, having talked to a lot of landlords throughout the state since COVID-19 began, we have relationships with many landlords throughout the state, and looking at the information that Minnesota Multi-Housing has put out there, landlords aren't, I mean, they're not thrilled with this, but they're not acting like it's the end of the world either, because we all thought, rightfully so, that things were going to be a lot worse than this. And again, if you look at the national numbers, 80% is about where we're at with the national surveys. So Minnesota's doing much better for a lot of different reasons, but it's still bad. It's still maybe twice as bad, or 2/3 as bad. 1.66 times as bad as it is the year before. That's how many delinquencies we're looking at right now. How many people simply aren't current with their rent. And it's important to share this information with as many landlords as possible, because I think every landlord's going to want to know, hey, wait, I've got, 1 out of my 10 renters not paying. Is that normal? Or I have 5 out of 10 that aren't paying. Is that normal? They want to get some idea of what the market is looking like right now. And this is the best information we have on the ground right now until the eviction court doors open up again officially. Okay, let's go on to the next slide. Okay, so once again, if landlords file, if they're going to file an eviction, we're going to talk about whether it makes sense to file an eviction in a second, but if a landlord is going to file an eviction, they've decided, they've looked at the numbers, once the eviction doors open up, whether that means the Minnesota moratorium is lifted, which will have to happen to make an eviction be fileable for non-payment of rent, or the CARES Act plays a role too. At some point, every landlord in the state is going to be eligible to file an eviction again for non-payment of rent. It's just a matter of when. But when the landlord comes to that point, if they're going to file an eviction, there is no incentive to wait. There isn't. The landlord's going to say, wait, I waited 5 months, I waited 6 months, I gave the 30-day notice that the CARES Act requires if they're covered by the CARES Act. Why would I wait any longer? So they're going to file as soon as they can. We've seen this in other states, by the way, where the eviction court doors have opened up again. There's a place in Ohio, Columbus, Ohio, where they have set aside an arena to host housing court cases for evictions because they know they won't have enough room. Now, obviously, some of that has to do with social distancing, but they need an arena to be able to host all the eviction cases that they're going to have to deal with. There have been news reports in Wisconsin where landlords were lined up hours before the court was even open in the morning, like it was the hottest concert ticket or Hamilton tickets, that they were waiting to get in line to file because they didn't want to have to wait any longer because they haven't been paid since March and they want to get somebody in the rental that can pay their rent. So if a landlord is going to file, there's no real motivation to wait, not really. And so our concern, I'm a lawyer and I represent tenants, and so I'm concerned about how this is going to affect tenants. I'm also concerned about how the courts are going to manage this. I just don't know how they can. Because if we look at what we have, the fourth bullet point down, 270 evictions filed per week in Minnesota on average. Those are the old numbers, 270. And we have 1,166 cases bottled up each month. That's our rough guess. Those are just the average years, not the new weird year where we have, maybe double the number of cases where tenants haven't paid their rent. That's 1,166 per month. If we just look at how many months we have that haven't been paid, which is April, right? May, June, and I'm counting July as well because the eviction moratorium goes to July 13th, so we might as well say July isn't paid as well. We're looking at 4665. That's the minimum number of cases that I think are likely to be filed as soon as landlords can file them. Now again, some landlords might, if the eviction moratorium is lifted on July 13th and on the 14th, the landlord can go file the eviction. Some landlords are not going to be able to because of the CARES Act. So maybe it will cut that 4665 in half, or maybe it'll be 20% lower, whatever. Again, we thought 20 to 50% of rental housing is covered by the CARES Act. But we're still looking at, even if that's true, 2,300 cases in a week, which is 10 times roughly the number of cases in an average week in Minnesota. So how will the courts manage this at all? Is there a way for them to get through this due process-wise? Many of you have been involved in evictions before. Some of you watching have never done an eviction. Some landlords never do an eviction in their entire career, depending on how many units there are and just sort of how things work for them. But if you've ever seen the eviction calendar in Hennepin County or in Ramsey County, what you'll see is a time block where 2 hours, 2.5 hours, where 20, 30, 40, maybe 50 cases, depending on the time of the month, are heard all in that time frame. I mean, things go through really quickly. To do 50 court cases in 2.5 hours, got to be hyper efficient. But if we're going to have 10 times the number of cases in that 1 week period, for the court to be able to manage that, can they add more blocks of time? Sure, they can add more blocks of time. They could have cases instead of 3 days a week, 5 days a week. They could go morning and afternoon. They could do night cases. They could do cases on the weekends, I guess. They could bring in more judges, I suppose. But look, the judges are going to be busy too. The courts have all been closed. It's not just eviction courts that are closed, but all kinds of cases have been paused or they weren't fileable. And so there's going to be a mass rush on the courts. There's going to be a lot of lawyers wearing a lot of suits, running to all the courthouses trying to file as many cases as they can because they have clients in every type of law where they've been waiting to file cases, waiting to file motions, and they haven't been able to do it for 4 or 5, however many months it's going to be. And so the CARES Act has a huge impact on how many are going to happen at once. If, let's say, the governor somehow figures out a way to calendar time things, so the eviction moratorium ends on July 25th, just like the CARES Act, and the governor says, you know what, but you have to give a 30-day notice, landlord, just like under the CARES Act, we're going to make everything parallel, then that's going to set us up in late August for that 4,600 number. First of all, we're going to tack on another 1,100, so we're up to 5,700. We're going to have that many cases eligible to be filed on maybe August 26th, if landlords go as quickly as they can. Now, some landlords, it'll take a little longer if they're required to give that 30-day notice. That's new to them. Minnesota does not require any kind of warning letter. We're in one of a handful of states that's not required. So if the governor decided to do that, or if the legislature decided to do that to try to mirror the CARES Act, it would probably be something that a lot of landlords wouldn't get right because they wouldn't know that intuitively because they've never had to do that before. But at some point, there's going to be one, if not two, massive waves of evictions that will be filed. And like I said, I think they'll be filed all at once because there's no incentive for a landlord to wait any longer than the hurdles they've already had to wait to get past. Okay, if you could go on to the next slide, Eric. All right, the last slide I have here, and then we're going to open this up for questions. We have several questions that were asked in advance. I think we still have time to handle those along with the few questions that have come in since we started. I've seen the numbers. So feel free to send along questions if you have them. Okay, will landlords actually file an eviction? So some of you are thinking, well, that's just a stupid question. Of course we're going to file an eviction the minute we have the right to do so. Okay, and you might. So many landlords are going to do that. But if I were a landlord, or if I were a landlord attorney, and again, I'm not, I just represent tenants, but as my job is working with tenants, I also have to think in virtually every case, what would a landlord do here? What should a landlord do? What's in their best interest? And so filing an eviction is something a landlord, once they can do, might be what a lot of landlords do, but there are going to be landlords that are going to look at the dollars and cents of all of this. They're going to look at this and they're going to say, wait a second, does it make sense for me to file an eviction? This is such a different time right now. As I mentioned earlier, most landlords don't wait 3, 4, 5, 6 months to file an eviction. That's really exceptionally rare, but now it's the norm. Again, landlords didn't choose this, but they've had to wait several months to go file an eviction. So the problem with rushing down to the court to file an eviction is what you win. What does a landlord win when they go file an eviction against a tenant? Well, what they win is they win possession. That's it. I mean, the easiest way to understand what happens in an eviction hearing is everybody walks in, the landlord and the tenant, they walk into court with their keys. And they put the keys in front of the judge on the bench. And then the judge decides at the end of the case who gets the keys. Now, sometimes the tenant might get a key that only works for a week more or something like that. But it's really the judge's or referee's job to figure out who gets possession. That's the only real power the judge has. These are strange cases. They're fast cases. They're called a summary proceeding, but they're limited kind of jurisdiction, what the judge can actually award anybody. It's really possession that they do. So a landlord that actually truly wins an eviction court case, what they win is possession. They don't win money. If a landlord wants to win money from one of those tenants, they actually have to go to a different court, probably small claims court, conciliation court, where you can sue for up to $15,000. But if a landlord sues there, landlords that have done this for a long time, they know that that doesn't mean they're going to get the money, even if they win. They'll probably win the case. There's a good chance the tenant wouldn't even show up to fight the small claims court case. But all they'll get at that point is a piece of paper saying the tenant owes the money. And then if they go transcribe that in district court, it becomes a judgment, which really does stop credit in many ways. If somebody wants to get a mortgage or maybe even a car loan within 10 years of that time, they're not going to be able to do it because of that blocked credit with the judgment on their record. So you might get a call as a landlord 5, 6, 7 years later where a tenant says, hey, I'm trying to buy a house. I realize that I still owe you $4,000 from back in 2020. Would you take 2? Is a very common sort of approach that a tenant might take, and a lot of times a landlord will say, no, I'll take 3, and then they end up splitting it at $2,500, and then the landlord's happy because honestly they never thought they were going to get another penny. But my point about all this is a landlord, and I know many landlords are going to do this because landlords look at their bottom line, and if they want to get money from the tenant that owes the money now, that's currently there, their best shot is to work it out with that tenant while they're there. And so what we're going to see, I guarantee this will happen. Let's use $1,000 as the rent because it's the easy math. You're going to see tenants that had some of the money to pay the landlord, but they didn't have all of it. And so a lot of tenants, they call us up. We talk to them. And they say, I've got some of the money, but I don't have all of it. What should I do with it? Should I give it to the landlord or not? I'm not sure, and I'm not sure if I'm going to need the money for the next place. And a lot of landlords are refusing to take the partial payment. Some are saying, we'll take the partial payment, which I think makes sense from a money standpoint, but I understand if landlords decide they don't want to right now. But anyhow, if the tenant goes to the landlord, the eviction moratoriums are all lifted. The landlord's eligible to file the eviction. The tenant says, you know what, landlord, I know I owe you $5,000. I have been saving up. I got $2,000. I got $2,000 I can give you right now. and I can pay you instead of $1,000 each month because my job restarted now, when we're all hoping everybody's job restarts as soon as possible. My job restarted now, and I can afford to give you $1,500 a month instead of $1,000. And I know it'll take me a few months, maybe 6 months or 8 months, but I can get caught up. Now, a landlord might say, well, wait a second, you owe me $5,000, you're offering me $2,000? No, I'm not going to take that. Get out, I'm going to get somebody in here that I can count on. Or the landlord's going to look around and realize, wow, how many people are in this boat? Am I going to be able to get anybody with, a more likely chance to pay me? And the new tenant certainly isn't going to pay the old tenant's back rent back. So if I want to get this money, the only way I'm probably guaranteed to get it at least soon is to work with the current tenant if they have a real offer on the table. I mean, if they offer you $50 and they owe $5,000, it's a pretty meaningless offer. But if they can offer you some cash that day and they have a payment plan in place, you can write it down, say what you're agreeing to. You put the date on it, you put the parties' names on it. You put in there that if the tenant has 5, 6 payments to make or whatever, and they miss any of the payments, you can go file an eviction at that point. And then you both sign it, you're pretty much locked in. Everybody's agreed to that. But once again, our concerns we have a lot of concerns about this from a tenant perspective, and I know a lot of landlords have concerns about this, but when and if the landlords are eligible to file evictions, finally, if a landlord decides to pull the trigger, there's no reason to wait. So there is going to be an avalanche or tsunami or whatever natural disaster equivalent you want to use to describe it. And that's our best guess of the minimum number of evictions that are going to be filed right away. And I think it's actually going to be a lot more than that. I think it could be thousands more than that number of 4,600 if the moratorium is lifted on July 12th. I hope not, but that's what we are expecting to see. Okay, I've talked for like 35 minutes straight, so I'll let Eric jump in and then we'll get to your questions.
All right, yeah, so we had probably 10 or so questions submitted in advance, and I'm seeing some in the chat and the Q&A, so we'll get to those. We're going to do the ones that sent in advance first, and then we'll get to those that have come in during the event also after that. So, but go ahead and submit more if you have them. So first, Alexandra sent in, are we allowed to give notice to tenants when their lease is up during this time?
The short answer is I don't think so, no. The governor's order is not just for banning evictions. It also bans the landlord terminating a tenancy during the peacetime emergency. This is something that we've been talking about every week. I wanted to get to this main topic about predicting the wave, but I don't mind talking about it right now. Termination of the tenancy, if the landlord gave a notice to vacate to the tenant or a notice to quit or a non-renewal for May 31st, for instance, what's the landlord going to do on June 1st? They can't go file an eviction for holding over, which would be the normal remedy. They have to try to wait at that point. The harder question, or at least we thought it was a harder question, was could a landlord give a notice today, June 25th, if it's a month-to-month standard lease, let's say, for the end of July? That would be the normal notice given. The way we read the governor's order, along with the way the Attorney General's office, which is who's supposed to enforce the order, reads it, is that giving a notice today for sometime past the emergency declaration expiration that we know of right now is still terminating the tenancy during the peacetime emergency declaration. So I don't think a landlord can give a notice to vacate at all right now, a notice of non-renewal or a notice to quit. The governor's order is built to make sure that tenants are allowed to stay in their home and not have to worry about being displaced. That's really the driving force behind it. And so I don't think a landlord can give a notice right now that means anything legally, and it's probably a misdemeanor to do so.
All right, Diane says she owns a duplex, private financing. Upper tenant has Section 8, lower tenant does not and is in breach of her lease. When is and then the question got cut off, but it says when is the first? I'm guessing when is the first time that either of them can be evicted? I'm guessing.
So the one that has Section 8, I think that was the upper tenant. I don't have that language right in front of me that Eric just read. I think that the CARES Act certainly applies there. The harder question is the one in the lower level probably does not apply, although I'm seeing mixed messages from different jurisdictions on whether that's true or not, that if a landlord is taking Section 8 vouchers somewhere else in the building, that they might all be covered. We haven't really seen that play out. We certainly haven't seen it play out in Minnesota. So it's hard to know exactly what would happen. The odd thing about this CARES Act is it is a federal law, but it's being interpreted by state courts. So we're going to see some variation on it throughout the states. Pretty much, I think it's inevitable unless there's at some point a Court of Appeals case or a Supreme Court case at the federal level that rules on one of these, which I think would be really hard to imagine why it would go that high up for a regular eviction, but I guess it's possible.
All right. Another question. I'm a landlord that lives with the tenant. I'm thinking about installing security cameras on the exterior of the property. Am I required to provide the tenant with a notice?
Yeah, I think we got this question yesterday too, and some of you watched the Wednesday show and the Thursday show. I would think at some point you'd have too much of me, but if you want to keep watching, that's fine, and I don't mind sharing the information. I don't think that that's illegal. I don't think there's any requirement that a landlord give a notice of the installation of the exterior camera. I don't know of any rule that says that. As I understand why most people put up signs saying there's an exterior camera, it's largely for a deterrent purpose to try to convince people not to commit crimes out there, as compared to warning people that there's a camera. I mean, if you're shooting in a public area in general, you have the right to record what's going on, as long as you're not trying to film something happening in the tenant's private space with some sort of enhanced unit that can somehow see through blinds or shades, or you install a camera inside somebody's actual rental unit. I don't think there's any requirement that there's a notice be given, but it's a little bit outside of landlord-tenant law, but that's my best guess.
Okay, and then we got this one submitted in advance, but it's also up in the Q&A box. Same question from Matthew. So I'm going to read it off of there. The peacetime order states no notices to vacate during the order period, which is until July 13th. The question is, can you still send a notice for an end date past that date, past the 13th of July, to comply with the proper notice period, 30, 60, 90 days, as it is called out in the lease? For example, should a landlord give proper notice now for a lease ending August 31?
Right, and we just sort of answered this question, but I really don't mind taking it on a couple of times because this is important stuff. This is the time of the year when landlords and tenants both are thinking about, okay, do I want to renew my lease for another year or not? This all happens in the warm weather months for landlords and tenants. And so Matthew asking about this, I really don't mind it, like I say, at all. And he's talking about giving notice now for the end of August. And I think giving a notice today for the end of August is violating the governor's executive order. And we've seen threatening letters sent by the Attorney General's office to landlords saying just that you can't terminate the tenancy today by giving a notice today, even though it's an effective move-out date at the end of July or the end of August, anytime past the peacetime emergency declaration. So if you have a lease that ends during the peacetime emergency declaration, but you don't want to renew for another year, what probably legally this is transformed into is a month-to-month lease with all the original terms of the lease still intact, like you can't have a dog or the number of occupants or who's going to be living there or whatever. But it's become a month-to-month lease versus another 1-year lease.
Okay, next question. Minneapolis already has parks filled with tents for the homeless. Landlords are looked at as bad guys, although they still have to pay insurance, property taxes, and utilities, even if the tenant does not pay rent. Now the eviction process may take over 6 months, and landlords could foreclose on their own property. The government put the landlords in quite a predicament. Why not create a robust emergency assistance program so tenants can stay?
Yeah, and look, that might happen. That might still happen. At the Minnesota level, at the Minnesota state level, both the Senate and the House each had bills that were proposed at various times in the last couple months that would have authorized additional funding to landlords through tenants, but it was going to the landlords, basically. Both of those bills didn't get passed. There was a lot of differences between the two houses, and so they couldn't reach an agreement. But that doesn't mean that there won't be an agreement if there's another special session on July 13th or 14th, which seems to be likely, that we'll see another special session if the governor calls another peacetime emergency declaration. Like I said, it happens automatically. More money could come from the federal level too. So it's possible. We were asked yesterday the same question: how do we influence the people that decide this stuff to make sure it happens? And the short answer is, look, if you're a citizen of Minnesota, you have a right to contact the governor and tell them what it is you want to have happen, what you think is fair or unfair. If you are a citizen of Minnesota, you have a senator, you have a state representative as well, and you should be contacting them to tell them what you think should happen here. I have no, again, I work for tenants. I don't want to try to seem deceptive here, but if there's no landlords, there's no place for my clients to live, right? I don't want landlords run out of business by any of this. I wish all the tenants could pay their rent. That would be ideal for everybody. And so hopefully that'll happen at the state or the federal level. I know there's even been some city and county money that has been apportioned for this purpose since the pandemic started. Yeah, we we don't control that. And if you want to make a meaningful difference, you might think by calling the governor or your state senator or state representative, it doesn't matter. But if a lot of people call or send letters or emails, then it starts to have an impact, especially on your local representatives, I think, whether it's a senator or a House of Representatives member.
And the state did receive something like $1 billion from the coronavirus relief fund from the feds, which was part of the CARES Act. I think there's $841 million that's sitting there waiting that could go to cities and counties. And I believe there's been some discussion that Walz has said about, acting on that and having some of it potentially go towards rental assistance type things. But I don't think anything's been acted on yet. Next question, an email from Abby. Any advice on what we should do regarding destruction of property? Is it considered a criminal activity or endangering others?
I don't think destruction of property fits in the governor's executive order. The governor's order was actually tweaked slightly a couple weeks ago. It used to say that a landlord could evict for let's see, the statutes. So that's, again, drugs, guns, prostitution, stolen property, domestic abuse, and also for seriously endangering the safety of other residents. That's what it used to say. Now it says seriously endangering the safety of others on the premises, but it doesn't talk about property damage. So I think if it's pure property damage and not endangering others, that no, a landlord can't file an eviction right now for that purpose, not under the governor's executive order.
And in the chat box, I've posted links to a number of the key executive orders, including that one that changed 20-14. That was 20-73. Okay, we are going to jump over to. Oh, this one was done. Okay, so Kimberly asks, tenant lets others stay or live at their house. Recently, a young adult overdosed in the basement. Police confiscated $56,000 from their belongings, and phone stated that they were selling drugs. Can we evict actual tenant if she is not being charged, but her guest staying there was, or if we find out other guests of hers are drug related?
So the statute I just referenced, Minnesota Statute 504B.171, and Eric will put up a link to that in the chat box as well. Doesn't really require much of anything beyond drugs being found in the rental unit. So I can't tell from this fact pattern that we got if that occurred, but that might be how the landlord files an eviction, and they might be able to file it now. I'll be honest with you, those cases are not simple. I would not attempt to do one of those as a landlord without hiring an attorney. There are landlord attorneys that are out there, and I can't really recommend trying to do one of those on your own. I think non-payment of rent cases are things that landlords can do on their own in general, but this kind of case, yeah, you'd want to get an attorney to work on it, but you might be able to file an eviction based on what you've described here for a violation of the drug statute that I just mentioned, because that is covered by the governor's order. That's one of the 2 carved out exceptions.
Okay, do you see this appliance lease clause one? Do you want to read that? You want me? It's pretty lengthy. Should we?
Let's do the other ones first, and we'll leave that one for last. But
okay,
we'll do it.
Have a chance to read it. Okay, so Kimberly asked, can we post a property for eviction today?
Ooh, I'm not sure about what that phrasing is getting at. I think you're just asking, can you go file an eviction today? Is that what you're reading this to mean, Eric?
Yeah, and this is the same Kimberly that asked about that had the previous question about potentially it could be a 504B 171
Oh,
eviction.
okay. So the answer is maybe you can, but again, based on the fact pattern you have, and trust me, I get no commission from this. It's not like landlord attorneys, the few that are out there, um, pay us some sort of referral fee. That's not how it works. I'm not trying to run up a bill in any way, but you need to talk to an attorney that does landlord representation to see if there's enough here before it would make sense to file an eviction. But you might be able to file an eviction right now, but I would talk to the attorney on this first.
Right. Jumping over to the chat now, are there plans to use a product such as LegalZoom to speed up the eviction process?
Okay, I mean, despite its name, LegalZoom, I don't think would speed up anything. LegalZoom, from what I've seen of it, it's a way to use standard court forms or easy ways to draw up wills, things like that. Things that people look at and think, wait, do I actually need an attorney involved to make this go faster? The UD process itself is a court process. It's not a paperwork process. I mean, there are papers involved, but the actual UD process, the day the landlord files an eviction in Minnesota, they're guaranteed court within 2 weeks of filing the case. Now, that 2-week rule is a statutory requirement, and the legislature and the governor, through a new law, have decided to relax those limitations. But we've heard that courts are saying, at least, oh, we're going to try to meet those deadlines, especially in housing court. Which I still think is hard to believe based on the numbers that we talked about earlier this hour, that the court will be able to. But LegalZoom, I don't know how it would help you with an eviction process at all, honestly.
So
Yeah.
Yeah, and Stephen sends in a clarification. Maybe he was talking about just the Zoom, the product, the video that we're using right now, and that is being.
Oh,
used
the
already.
court, the actual like showing a video. You mean is what you
Right.
think it means? Oh, that's just Zoom, I think.
Yeah.
Yeah.
And the
Although they
courts
might
are
call
using.
Yeah, they might call it LegalZoom for courts. Will it speed up the process? Oh no, I think it's going to slow the process down dramatically. It's going to be slightly easier in one way for people because they don't have to go to the courthouse. But in the courthouse, if they have 100 cases, it's a lot easier to go through those cases if everybody's there. They're going to be losing connections with people, people calling the wrong number, and glitches. I think it's going to be much slower with the LegalZoom process than the in-person approach that used to be taken. So yeah, I don't think it's going to speed things up at all. And I see that Stephen has a second part to his question. The landlord's suing the government.
Yeah. So Steve asks, can the landlord sue the government for financial damage to business?
There's a phrase that lawyers have, which is you can sue anybody for anything. The question is whether you're going to win. I'm not sure. There might be some governmental immunity that stops this from happening. I've never seen a case tried like that. Yeah, I mean, I guess a landlord might argue some sort of eminent domain taking clause-ish argument that, hey, I had property, I had an asset that wasn't paying me what it was supposed to, and it was because you told tenants not to pay me. So there, I get the theory behind it. I'm just not sure how good that footing is, having never either represented a landlord or seen that kind of case filed. Again, we're going to see look, so many parts of our lives are turned upside down, and we're focused on one tiny piece of that right now, which is the court process for evictions in Minnesota. But still, we're talking about things that we don't have precedents for, so it's really hard to know what would happen if that kind of case were filed, unfortunately.
And something that you said remind me that the government, the Walz administration and Minnesota Housing and the Attorney General's office has said that the orders say rent is due, so they haven't been saying don't pay your rent.
Right, you're right. I have not mentioned that today. I've mentioned it in most of our other sessions. But yeah, the rent's due. There's no question that the rent is due. And the governor could have said otherwise. The governor could have said rent's canceled. Nobody owes rent. So could the CARES Act, but they didn't say that. They said the rent is still due, and that's why 88 to whatever it is, 95% of tenants have paid is because the rent is still due.
All right, got quite a few of them in here still, so we're going to plow through them.
And we'll try to get through as many as we can, and stick around late if we need to.
Stick around a little bit longer. Debbie asks, can you clarify for us, we have a tenant who's on a federal subsidy who we need to terminate or evict, not because they have not paid rent, but because of so many other violations of lease, not criminal. Do we have to wait until July 25, or can we terminate evict when the governor's order lifts?
Okay. So if there's a federal subsidy, the CARES Act only comes into play for non-payment of rent. So for any other breach of the lease, including an unauthorized occupant or anything like that, you could file. The CARES Act doesn't really play a role. But you still have the Minnesota hurdle to get past. And since you mentioned this isn't criminal, I assume that it's not endangering others. Then until the governor lifts the moratorium on evictions, you can't file the eviction. So one of the hurdles isn't there for you, which normally it would be because it's usually non-payment of rent and you've got a federal subsidy, but that's not your issue. But you still have to get past the second hurdle, the Minnesota moratorium, which until that's lifted, you still couldn't file for what you've described here.
Yeah, and then there's a comment here. I'd like to comment that if landlords could provide notice of back due rent, tenants could then seek help with community action agencies to help with that, and eviction notice is not needed. And that's exactly right. It's one of the things that we've been sort of saying since the beginning, is that having some sort of a notice period would provide tenants the opportunity to seek. To use that letter to seek emergency assistance.
Yeah, and that's pretty much the idea behind the CARES Act, 30-day notice as well. Because in some states, well, in most states, it's not a 30-day requirement that a landlord has to give to a tenant. It's a lot lower than that. So the federal CARES Act, making a 30-day uniform rule across the country, was designed for that. So tenants could go to emergency assistance or to their church or to a friend or to a family member and see if they might be able to come up with some money because they have this official declaration from the landlord saying what they owe and when it's due by. And so even if the governor lifts the moratorium and there's no notice requirement required by the state, it might still be in the landlord's best interest financially to do one of those types of notices.
And then another piece of advice coming in, refer tenants who are late on rent to their county for CARES funding for eviction prevention before filing an eviction. And I'll put it in the chat. There is, for example, Hennepin County does have like a one place go to online and a phone number, and I'll post it in just a minute here for rental assistance that it's being used right now. So okay. Just clarifying that CARES Act protection for evictions is only for evictions for the sole purpose of non-payment of rent, correct? Asked Amy.
That is correct. The CARES Act is just about non-payment of rent. By the way, the CARES Act prohibits late fees as well. So if the CARES Act covers a rental unit, late fees are not allowed. Minnesota, the governor's eviction moratorium does not stop late fees from being assessed.
Yeah, late fees too. Okay. Kimberly asked if we accept partial payment for a month, does that preclude landlord from filing eviction when allowed when the ban is lifted?
Okay, so this is a really good question, Kimberly, and it's one of those questions that I get a lot from landlords. Should I ever accept a partial payment? And my answer to that is always this. It's another question, which is, landlord, are you in the eviction business or are you in the rent collection business? If you're in the eviction business, never accept a partial payment ever. If that's your primary goal, is to always win every eviction you ever file, never accept a partial payment. That would be my advice. But if your goal is to try to collect rent, then I would say, okay, I think you should listen to what the tenant is offering. And if it's a substantial offer, then there's a partial payment defense to evictions. That's why landlords are nervous about accepting partial payment. What that defense wants a landlord and a tenant to do is write down what they're agreeing to say what they're agreeing to. That's it. So like I mentioned earlier, it's going to be a piece of paper. It doesn't have to be drafted by a lawyer. It doesn't have to be notarized. It says at the top, today's date. It says who the parties are. It names the address of the place. Maybe it'll mention what the original lease term was for, how long, and what the amount was. And then it'll say, hey, the tenant's behind. They owe $5,000. They agree to pay $1,500 on August 1st. They agree to pay $1,500 on September 1st. And then it goes on, and it lists all the dates when rent is due and how much it's due. And then it says if the tenant misses any of those payments, that the landlord can go file an eviction. It's signed by both parties. You've just wiped out the partial payment defense. That's what the partial payment defense wants you to do as a landlord and a tenant, is to write down what you're agreeing to so everybody knows what's being agreed to. And then you're covered. And then you've got some more money in your pocket is how I base that advice.
All right. HRA agencies, are they do they have to follow the CARES Act?
I think that that's going to be a blanket yes. I'm having a hard time in my mind thinking about when that wouldn't apply. Eric, do you think there's any?
Uh, I mean, it depends on what I mean, public housing is covered. So
Sure.
different HRA agencies may be operating other state programs that potentially might
Yeah, no,
not, but
I guess you're right. And again, the CARES Act is only about non-payment of rent. So if there's another breach, then that wouldn't be covered by the CARES Act too.
yeah. Okay. Patricia asks if we can't give notice on a lease that is ending past the CARES Act date. What is the best approach to make sure we are in compliance with the lease term, 60 days notice? This is for a tenant that has not paid for months and not the landlord would not like to keep. Eviction is a lose-lose situation, so we'd rather not go that route.
Right, Patricia, you're right. An eviction is a lose-lose for everybody, right? A landlord goes and files an eviction, that's $300 out of their pocket guaranteed. That's just to file the case. They hire somebody to serve the court papers, another $100. They hire an attorney that does this work. What's that going to be? 200, $500? So we're looking at, what are we up to? $700 to $1,000 probably, realistically, that a landlord is going to have to pay to file an eviction against somebody. So right now, a landlord just doesn't have the leverage that they normally do when it comes to a tenant that isn't paying their rent. The landlord can't go to them and say, I'm going to go file an eviction if you don't pay. That's a meaningless threat right now. At some point, that threat won't be meaningless. And at that point, you know, how much sense does it make for the landlord to go file the eviction versus going to talk to the tenant and say, I don't want to file an eviction. You know how much money you owe. Here it is. Here's the number. You can't pay it, right? Or can you pay it? If they say yes, then you work out a deal. If they say no, I can't pay it, then okay. You would talk to the tenant and say, well, I could go file an eviction, which is going to cost me a lot of money, or you can just leave. I know some landlords who actually pay tenants to go in that situation. Instead of paying that $700 to $1,000 for a pretty normal eviction, if you're going to get an attorney, they will give the tenant the filing fee. Here's $300. If you leave by next Sunday, I'll pay you to go. And you swing by that Sunday, make sure the place looks okay, and then they give you the keys and they get the $300. I know how counterintuitive that sounds, but if you look at the dollars and cents of it, maybe it's not such a bad move. But right now, a landlord threatening to give a notice, well, first of all, giving a notice, I think, is a violation of the governor's order right now. So you have to wait until that leverage changes and your position changes and you have the right to file the eviction. But once that happens, you can certainly talk to the landlord or the tenant and say, I'd rather not file an eviction. Let's just figure out a way to do this without court. And tenants and landlords do that all the time. Pre-filing mediation, if you want to give it an official name, and there's mediation agencies around, certainly around the metro, that might be able to help you with that too.
All right. Before we get to this lengthier question, well, I'm gonna mention this thing quick. Kim says I'd argue that the 2-week time frame, I think this is the court time frame for hearing eviction. I would argue that the 2-week time frame is 2 weeks from when the court issues the summons and not the filing date.
I don't, Kim is an attorney and she actually used to volunteer in her office, and now she, as I understand it, works mostly for landlords on the landlord-tenant disputes, but also for tenants some of the time. And Kim, I don't think that's right. I think that it's 2 weeks from the day of filing, but I don't have the statute right in front of me. And so I apologize. Although I work in this world and kind of live in this world, and now my statute disappeared. I can't look it up. I think it's 2 weeks from the day of filing, but I'm not so confident that I'm going to tell you that I think you're wrong about that. But that's my guess. But sorry. Now we still have Madeline's big question, right?
Yeah,
that we
there's another one that came in.
Okay.
Can you elaborate on using security deposit as last month rent payment and the potential penalties for tenant for doing so?
Sure. So a tenant is not allowed to unilaterally use their security deposit to cover their last month rent. That's found in the security deposit statute, which Eric will put in the chat box. The penalty against a tenant for using the last month unilaterally for rent deposit for the last month's rent is honestly very rarely employed correctly by landlords. They have to give a notice at that time contemporaneously saying that, hey, you can't do this, or else the penalty is whatever damages the landlord discovers like bad carpet or whatever, is doubled. So there is a penalty. It's rarely enforced, but a tenant is not, on the letter of the law, allowed to use their deposit to cover their last month's rent. Now, a landlord and a tenant can agree to that. The only time I typically see a landlord agree to that is the tenant has already given up possession. They're no longer physically there, because the landlord wants to assess the conditions, right? They want to see, and the truth is that the two most common times you'll see damage occur is the day the tenant moves in and the day they move out, because they're moving big things around. They might put a big hole in the wall or break a window accidentally. So landlords are really reluctant to say, go ahead, I'll use your deposit to cover the last month's rent. So there you go.
Okay, and one other question came in. To clarify, if a tenant will not sign an agreement for remaining payment but pays something, does accepting it give them a defense? We are trying to get agreements, but if they won't sign but pay partial.
So I'm sorry, they're taking partial payments, but the tenant refuses to do an agreement in writing?
Tenant will not sign the agreements.
Yeah, I mean, that does make a landlord in a much more precarious situation. Just so we understand, partial payment defenses don't work forever. They work for the months that it's covering. So if you took a partial payment for June's rent right now, and then we roll over into July and the tenant doesn't get caught up, if you refuse rent that month, then you'd be filing the eviction for July plus the past months. But the partial payment being accepted in June doesn't work for the tenant for future months.
All right. Okay, so we're over right now, but we've got a question from Madeline that's a little bit lengthy. I'm going to be reading it. I'll put it in. Everybody should be able to see it, but I'll put it in the chat too. Maybe I can't copy it. All right. Well, Madeline asks, I'm not sure. Talking with a friend who owns a duplex, and there's an appliance clause in the lease. Is this legal to add? Appliances. Any and all appliances provided by the landlord are there for the tenant's use and enjoyment, but are not part of the rent. If the tenant uses the appliances, the tenant is responsible for appliance repairs and maintenance. If landlord is made aware of damage to or loss of function of an appliance, landlord may choose to repair the appliance at the tenant's expense. The landlord is not obligated to make any repairs or replacement of these amenities. If an appliance breaks due to the negligence or abuse by tenants or tenants' guests, tenant is responsible for replacing the appliance. Unless otherwise indicated, such loss or damage will be presumed to be the fault and responsibility of tenant. Tenant certifies that the following appliances are present and in good working order upon move-in: range, stove, refrigerator, dishwasher, washer, and dryer.
Yeah. Okay. So what this is what I would call something of an appliance disowning clause that the landlord is trying to use here. And leave it on the screen, Eric. Don't take it away in case I want to look at it again. So is that legal? I would start with this. I would look at the landlord's ad. If they ran an ad on Craigslist, if they had an ad in the newspaper or anywhere, and see what the ad promises. This is from a tenant advocate perspective, but this is how I think a court would look at it as well. And so if the landlord promises washer and dryer, let's use that as our example, a washer and dryer, because there's no code that requires a washer and dryer. It's just something that's either promised or not promised in the lease. So there's a washer and dryer. Then the washer and dryer breaks, and the landlord has this in their lease, and it says what it says. All right, so the landlord is going to say, wait a second, you signed a lease, you've agreed to this contract. The tenant's going to say, well, wait a second, you promised a washer and dryer in the ad. You didn't put in your ad that there'd be some sort of thing that said that I have to pay to fix the washer and dryer if it broke. You needed to put that in your ad. This was a bait and switch, effectively. You didn't give me what you promised to give me. I like the tenant's argument there. If I'm a landlord, I'm not going to include washer and dryer. The harder question is when you got the refrigerator and the stove, which is apparently included in this list. Those are going to be seen as essential items, and for a landlord to try to disown those is effectively trying to transfer the duty to repair to the tenant, which I think violates 504B.161, and so I don't think that part would hold up. It has a better shot of holding up on a washer and dryer or a dishwasher than it does on a fridge, for sure. But again, if a landlord really wants to go this route, they need to be very consistent in all their communication with tenants, including their ads, saying fridge not included. Tenant, you will be paying for your own fridge. I think you're going to find a lot of tenants that say, "Ooh, I'm not interested. I'm not even going to call the landlord for that reason." So a landlord being consistent in their advertising and during the showing as well, I think the landlord needs to affirmatively disown that fridge at that point. Point it out and say, "Hey, that fridge breaks. It's on you to fix it." The tenant's going to stare at you with an open mouth saying, "What?" That's just not what landlords do generally. I've seen it with air conditioners, window air conditioners. I've seen it with washers and dryers, some extent a dishwasher, but they're so built in that it doesn't make a lot of sense. But I think a landlord truly has to affirmatively disown those appliances throughout the entire process, or else there's a real danger of a bait and switch there.
All right. So thanks everybody for joining us. I did put in the chat the link to Zoom registration for our webinar next week, next Thursday, and you can also sign up on the website like the screen says. Next week, Mike will be gone, but we will be joined by Homeline's housing attorney and research director, Samuel Spade. And
let me talk about next week for a second. I talked to Sam this morning about it, and he has decided that he's going to cover prediction, but on a more localized level, a 7-county prediction. So he's going to be looking at the metro area. And he's also going to be doing sort of a seasonal analysis that some months have more evictions than others on average. He's done all kinds of reports as our research director in the past. And it'll be interesting that he's going to look at this localized thing and also looking in time when evictions are most likely to happen during the year. By the way, I also wanted to address Kim's question because she's talking about the summons. She's right, literally. It says the court issue a summons, court issues a summons, and that the appearance will be within 7 to 14 days of the issuing of the summons. So that's the key question, is when is the summons issued? So I guess the court, if they really wanted this to take longer than the 14 days, wouldn't issue the summons right away. This really depends on which county you're in. A lot of times if you're doing this at the counter, they'll give you the summons right there, so it's immediate. But I guess the court could delay these cases by not giving a summons to the landlord right away. The practical effect in general in the past has been it would be 7 to 14 days from when they filed it because they get the summons right then. But I guess the court could slow things down that way if they wish to.
All right. So thanks. I'm getting some chats and Q&As of thank you for joining us. We're trying to be as helpful as possible for tenants and landlords and to get through this. And in case you didn't get the link to the registration, you all, everybody who's participating will get a follow-up email that has a link to the recording for today and previous recordings, and then where you can register for next Thursday. So with that, we will call it a day. Thanks everybody.
Thanks.